Good afternoon and welcome back to Supreme Court Now. My name is Luis Ibaedo, and today we're going to be looking over the last two cases that the Supreme Court of the United States is going to be looking over during their October 2020 term. These two cases actually have to do with some pretty hot topics going on around in our current political climate, the first being police brutality and the second being immigrant rights. So with that, let's get into our first case. So Torres versus Madrid. This case has to do with police brutality. It is Torres suing New Mexico State Police, Madrid, and his partner. So let's look to July 15th, 2014 in Albuquerque, New Mexico. Two New Mexico State Police officers were looking and had a warrant for Miss Kayenta Jackson. When they arrived to Miss Jackson's apartment complex, they noticed two females who they stated looked suspicious in the parking lot. Um, the issue arises because the females did not know that they were police officers. In fact, they were driving in unmarked cars and were wearing very dark clothing and tactical vests. And when the officers confronted the two ladies, a confrontation ensued. So Torres and her friend fled the scene in their car. And as they were driving away, the officers fired multiple shots at the car, and two struck Torres in the back. And so she got away from the police officers, but later the gunshots wound proved to be too much, and she admitted herself into a hospital, and there she voluntarily turned herself in to the police. Now, the case arises because Torres is suing the police officers for excessive force. Basically, in her defense, she didn't know they were police officers, and in her eyes, they shot her for no reason because she did not know that she was being detained. And so her petition cites the Fourth Amendment saying, look, this is unreasonable search and seizure. I was not the person on the warrant. I did not deserve to get shot twice in the back. So the district court actually ruled in favor of the police officers because they stated there was no seizure because she was not arrested and physically brought in and detained. And so after the case did not go in Torres' favor, she appealed to the 10th Circuit of Appeals in Denver, Colorado. And in that court case, they decided the same thing. They said that, look, the district was right. Because you were not arrested, you haven't been seized, and therefore your Fourth Amendment has not been violated. And so with that, Torres has filed a writ of certiorari, and now the Supreme Court is going to see this case on tomorrow, October the 14th. And so I think what the Supreme Court is going to be, the biggest task is going to be to determine and to really specify what the Fourth Amendment applies to. And the biggest question here is, if you are not physically taken in by the police, are you considered seized? And therefore, if you're not, then your Fourth Amendment hasn't been violated, and you can't sue the cops for excessive force because they never technically detained you or arrested you in the first place. And so the Supreme Court is going to really have to look at the Fourth Amendment and determine whether or not an unsuccessful attempt to detain a suspect by the use of physical force, is that a seizure under the Fourth Amendment? And with that, let's get on to our next case, Pereida versus Barr. And if the name Barr rings a bell, that's because this is William Barr, the Attorney General of the United States. So the background on this case is Clemente Pereida lives in Nebraska, and he pleaded no contest to a criminal charge where he was found guilty of using a fake Social Security card in order to get a job. And although Pereida is a legal alien in the United States, not an illegal alien, a legal alien in the United States, because he committed a crime, the Department of Homeland Security started his removal proceedings or his deportation process. And Pereira filed a petition to stop his deportation process. And basically his means to do this were that he is not in violation of the Immigration and Nationality Act. And so with that, let's go ahead and look into the statutes and see what they say in specific and whether or not the court is going to decide if he violated these or not. So under U.S. Code, Chapter 8, Section 1229B, subsection B, it reads that the Attorney General may cancel removal and adjust the status of an alien lawfully admitted for permanent residence is inadmissible if, and here's the big if. A, has been in the United States for a continuous period not less than 10 years, which Mr. Pereida has. B, has been a good moral character. Well, he is found guilty of fraud and using a fraudulent social security card, so that may be kind of iffy. This is where the court is going to have to look. C, has not been convicted of offense under 1182A, 1227A, and 1227A3. And what these three statutes are is did not commit a crime while under the age of 18 with more than a maximum penalty of 1 year. He checks that box. Has not committed 2 or more crimes involving moral turpitude. He checks that box as well. Or the last one, has not committed a crime involving an aggravated felony. Checks all 3 of these boxes. And so the last one is D. The removal would result in an exception or an extremely unusual hardship for the alien's spouse, children, or parents who is a United States citizen. And he does check this box because he has 3 daughters in the United States who are legally citizens. They're born here. And so Mr. Pereida brought this case to an immigration judge and he was denied. And when he said his appeals for the Board of Immigration Appeals, the judgment of the initial judge was affirmed, meaning that they both found that he is in violation of the U.S. Code because he has not been a good moral character. And now this is going to be seen by the Supreme Court. So what the Supreme Court is going to have to decide is, what they're really going to be looking at a lot is moral turpitude. And moral turpitude is defined as an act that gravely violates sentiment or accepted standards of a community. So for example, I live in Houston, Texas, and crimes dealing with marijuana are not morally turpitude, meaning that it is illegal here. Whereas the same exact crime having to do with marijuana in Los Angeles, California is not morally turpitude because in fact it's legal there. So it is going to be difficult for the Supreme Court to decide because, well, let's go back to what we were talking about earlier in the U.S. Code, right? Subscript B was that has been a good moral character, referring to whether or not the immigrant can apply for an appeal if they have been a good moral character. So the Supreme Court is going to have to decide what is a good moral character, what is the solid definition of moral turpitude, and is a misdemeanor crime like using a fraudulent ID to get a job, is that morally turpitude or not? So that is what the Supreme Court will look at, and I'm excited to see how that will go. Thank you guys for watching. Those are all of the cases for October 2020 that the Supreme Court is going to be looking at. With that, they will not look at any more cases until November 2nd, right around election time. And by then, hopefully they will put out all of their opinions and decisions on the October 2020 cases. That way we'll be able to look over them, see what changes, see what maybe won't change, and then we can look forward to some new cases on the docket. And with that, thank you guys for watching. Adios.